Hi, David.
Good morning, Judge.
Am I on a pause?
No,
Okay. I'm sorry to hear about your loss. Anna told me.
thank you very much. I'm heading to the airport as soon as this is over.
So
Go ahead.
I'm getting a repeat. So I'm going to maybe I have YouTube on. Let me see. I do. Okay, so I closed YouTube, so hopefully I'll be okay now.
Okie doke.
I don't think this is going to last very long, but what time do you have to leave?
About 11 or 12:30.
Oh, okay. No, that won't be a problem at all.
Good morning, Madam Hearing Officer.
Good morning, Elizabeth. How are you?
I think I have my volume off. Let me check. Hold on. There we go. Can you hear me?
Yes.
Oh, very good.
How are you?
I'm great. How are you?
Okay.
Good.
So has Brad got you working on the P&M cases?
So he's introducing me slowly to a little bit of everything, which is kind of nice, actually. But it's an adjustment for him to start including me on his stuff. So sometimes he forgets to forward things. So we had a little talk about that yesterday.
Okay.
But yeah, it's getting more interesting. I'm certainly getting more assignments, and yeah, and like you, I'm finding it more interesting than I thought it would.
Good.
Yeah. How are you, David?
Good. How are you?
Good.
Have we met somewhere before?
Yeah, we have, just on another call like this. And you probably meet tons of people all the time.
As luck would have it, I do.
Yes.
Mhm.
Where is everybody? Let's
Yeah. Usually more people have signed in by now.
Yeah.
Do you have to admit them?
Yes. But I do that immediately.
There we go.
And I expect, quite a few people on this call.
Yeah. Good morning.
Hi, Leslie.
Good morning. How's everybody?
Okay.
Great.
I don't think I've met Elizabeth.
Hi, I'm new to the legal division at PRC.
Hi, I think Brad Borman mentioned you last week. Well, congratulations. Welcome
Thank
to
you.
the PRC.
Yeah. It's
Not
been
quite at the
already.
not quite at the PRC yet, though.
Well, I don't know when that's going to happen exactly, but we'll see.
You won't have the experience of the para building at all then.
Oh, I've been in it for other reasons. It's
Uh-huh.
the building I'm endeared to. The elevator always bothers me because you like start out on the second floor, which is really weird to me, but yeah.
Or was it second or third?
Third, maybe? I don't know. It was an odd
It
elevator.
was odd.
Yeah. Good morning.
I heard that, and I don't know if this is true, that there's superstition behind that, and that 3 was considered an unlucky number or something, but I don't know if that was true.
That's an interesting thing. Huh.
A part of the parking lot there was built on a cemetery.
Really?
Oh, no kidding.
Yeah,
Oh.
that's where some of those rumors and legends initially grew from.
Okay.
This is the PERA building?
Yeah.
One of my former really poor paying jobs, I was a security guard, and I had to roam around the PERA building at night, making sure that office doors were closed. And I swear you could hear some creepy sounds, in the stairwells.
Wow.
La Llorona, she was looking for her lost baby when they dug up the old graveyard and they separated her from her baby. That was the legend. I was a little spooked, but I had a gun, so I was okay.
They let you wander around with a gun?
They were very irresponsible.
That's really scary, Peter.
They were just, they let anybody do that. So,
Jeez.
frankly, I got a letter from the governor when he found I was going to law school and made sure that I wasn't going to do that again.
Wow.
I'm not clear about in New Mexico when you can carry a gun and if it has to be concealed or in the open and if it's different in the Capitol building. Anyway.
I'll call you.
Ah, okay.
It's actually very complicated. The law is supposed to be simple. We're an open carry state, but at every jurisdiction, every store can choose to say, no, you can't do it.
Okay.
Mr. Swepke, I don't know if this is a good thing or a bad thing, but when I saw you, I thought you were Steve Michael.
Well, at least we have the same first name. You just say Steve and we'll answer.
Yeah.
So listen, I'll be free and
David, are you ready?
Yes, Your Honor.
Okay, let's go on the record. We are here for a status conference in case number 21-00083-UT. And I will start out by taking appearances. And I will first just go through the list of parties as I see representatives. Who appears for PNM?
Good morning, Madam Hearing Examiner. Leslie Padilla for Public Service Company of New Mexico. With me are Counsel Rick Alvidrez and Raymond Gifford. Also with us are Nick Phillips, who's Director of PNM's Resource Planning, and Steve Schwebke from our Regulatory Department.
Who appears for Bernalillo County?
Good morning, Madam Hearing Examiner and David. This is Jeff Albright, and I'm representing Bernalillo County.
Who appears for New Mexico area?
Good morning, Madam Hearing Examiner. Kelly Gould and Peter Gould for New Mexico Affordable Reliable Energy Alliance.
Who appears for Bernalillo County Water Utility Authority?
Good morning.
Good morning, Madam Examiner. Keith Herman and Dal Harris representing the Albuquerque-Bernalillo County Water Utility Authority.
Who appears for New Energy Economy?
Good morning, Madam Hearing Examiner. Mariel Manassi on behalf of New Energy Economy.
Who appears for Western Resource Advocates?
Sydney Beatles for Western Resource Advocates. Good morning.
Good morning. Who appears for the Coalition for Clean Affordable Energy?
Stephanie Zur on behalf of the Coalition for Clean Affordable Energy. Good morning.
Good morning. Who appears for the Attorney General?
Good morning, Madam Hearing Examiner. Gideon Elliott for the Attorney General.
Who appears for Interwest Energy Alliance?
Good morning. This is Joan Drake on behalf of Interwest Energy Alliance.
Did I miss anyone?
Madam Hearing Examiner, this is Jeff Albright from the county. I did hear from Jane Yee for the city of Albuquerque. I don't know if she has formally entered an appearance. I didn't check, but she will be unable to make the call this morning, and I agreed to convey any of the proceedings to her later on. I do believe if she has not entered an appearance yet, that she plans on doing so.
And I apologize, Mr. Throne.
Yes, good morning, Madam Hearing Examiner. Bruce Throne for Onward Energy Holdings LLC. I'm assisting Mr. Yar, but he couldn't make it today, so I'll be representing Onward Energy today. Thank you.
Madam Hearing Examiner, I'm just wondering when Mr. Throne is going to make good on his promise to retire.
I'm trying mightily.
Okay, did I miss anyone else?
Madam Hearing Examiner, Brad Borman appearing for staff. I'm joined by Elizabeth Jeffries.
Sorry, I apologize, Mr. Borman and Ms. Jeffries.
It's all good.
Anyone else? Okay. First, I want to apologize to all of you for the late issuance of my notice regarding the status conference, in which I said my intent is going to be to adopt the procedure adopted by the hearing examiners in case number 19-00195-UT for accessing PNM's modeling software and data. I didn't have time until Tuesday to take a good look at the filings in the IRP case and the order issued in 19-00195-UT. I think, as I said in my notice, that it is more appropriate to use the procedure from 19-00195-UT because the requests made by PNM in this case are very similar to the requests from that case. And the IRP case is really a different animal. I don't know if Mr. Lennon will be following the method that I adopt in this case or not. And I talked to Ashley Schnauer, who was one of the hearing examiners in case number 19-00195-UT. I asked him whether any issues came up after he issued that order that I attached to my notice. He said no, the procedure seemed to work well as far as he was concerned, and he agreed with me that that procedure should be followed in this case. So the purpose of today's conference is I just want to know whether, I think most of you probably participated in case 19-00195-UT, and I just wanted to know whether there were any issues with that procedure that were not brought to the hearing examiner's attention that you think might need to be tweaked. And so I'll begin there. If anybody wants to, Ms. Padilla, you can start.
Sure. Yeah, Leslie Padilla for PNM. Thank you, Madam Hearing Examiner. I noted in the order in the 19195 case there on page 8 there was actually some language that that explained that the hearing examiners noted that this was the first occasion on which such a procedure was developed, and adjustments may be warranted as PNMs and the parties actually implement the procedure. So we do have a few things we'd like to suggest. We would like additional time to respond to requests for modeling runs. Preferably probably a hard deadline. Of Mr. Phillips can speak more to what he and his team actually need. But we do feel we need more than the 11 days that we have agreed to for discovery responses. And then second, I would also note that PNM is amenable to NM Area's proposal about providing access to the two databases. Again, Mr. Phillips can provide more information on that, and we would offer that, in the hopes that requests for modeling runs, can be kept, as minimal as possible, just to preserve, PNM's resources, but with the goal of providing people the information that they need to put their cases together. I also just really feel like I wouldn't be being fully responsible to not state what I stated in our statement of issues, and that is we do feel that this, notwithstanding that this was agreed to previously, that this is contrary to the statute that requires parties to provide for their own costs of litigation. So just wanted to note that, but thank you.
Okay, thank you. In response to your first comment, asking for additional time, more than 11 days to respond to requests for modeling runs, page 10 of the order in case number 19-00195-UT does say that in addition, the 11-day turnaround for discovery requests should not apply to the requests for modeling runs. And I wanted to ask whether a deadline was ever set in that case for PNM to respond to requests for modeling runs.
Okay. Could I ask either Mr. Alvidrez or Mr. Phillips to respond to that? I am personally unaware.
Was that Miss Phillips? I'm sorry, Miss Padilla?
Yes, that was. I apologize, Mr. Lee. That was.
All right. If everybody could state their name before they speak, I just can't pick your face out amongst the crowd.
Certainly, this is Nick Phillips for PNM. I can respond to that question. And I guess the first thing I would note is it would be PNM's preference to, if parties just take access to the software and do their own analysis. We understand Mr. Gould's position. We're happy to provide and pay for the licenses, but it would be PNM's preference to have parties do their own analysis as opposed to doing modeling requests on behalf of parties. There were some issues that arose that may not have been known to the hearing examiner within the 195 docket. Some of those issues just related to the volumes of requests coming into last minute, especially during rebuttal, that turned into very difficult times to try to perform that analysis when not given enough time to do so. Early on in the process, when parties provided enough notice of modeling runs and we were able to work with them, we were able to tell them, hey, we've got X number to do, you're third in line, and parties were pretty okay with waiting until we could get to it. But as of course testimony deadlines approached and the parties didn't get requests in time, There were actually some circulated motions to compel that end up having to be resolved between parties and created very big difficulties trying to do things in such a short time frame. So, given that, and I'd actually addressed this in my rebuttal testimony in the 195 docket, we would prefer if parties just took access to the software and data as provided and performed their own analysis.
Okay,
But
I
was just going to
understand.
ask Mr. Phillips to respond to the question about was there a specific time, Nick, in our revised proposal in the 195 case?
The 195 case said that we would do our best to meet the discovery turnaround, but in the event we did not think that we could, we would work with parties to provide the results as quickly as possible thereafter. And so we would talk with parties, make sure we understood the request, and then if we couldn't get to the...
I've lost him.
Yeah. Mr. Phillips, you're frozen. We can't hear you.
If he comes back, I think that was almost the complete answer, though, to the provision in the 195 case about what we would agree to. And I think we would want an agreement that the 11-day discovery request should not apply, but P&M will do its best.
Okay. Mr. Phillips, you might try leaving the meeting and then request readmission, and I'll admit you right away. So I'll give you just a minute to try that.
Looks like he's doing that.
Okay, I just admitted him.
I apologize for that.
Okay, Mr. Phillips, did you have anything to add? I think the last thing you said was that in 19-00195-UT, P&M agreed to do its best to meet the 11-day turnaround, but would work with the parties if that wasn't feasible.
That's correct. If we did not think we could meet the discovery turnaround, we would work with parties to provide it as timely as we could thereafter. That's correct.
Okay, does anybody else want to address that issue with respect to the time for P&M to perform the modeling runs? Yes, Mr. Albright.
Yes, Madam Hearing Examiner, Jeff Albright again on behalf of the county. I just want to, for clarity purposes, we're still maintaining the 11 days for discovery other than the modeling runs. Is that correct?
Yes, I believe that's in my procedural order.
Okay, thank you.
Mr. Throne?
Yes, Madam Hearing Examiner. In the statement that Onward filed on Tuesday, beginning on page 8, we had a number of requests to try to clarify timing issues on this. The statement explains the basis for it, but some of these go directly to the timing issues. So I would like to address that if I can.
Give me just a minute. I thought, okay, I have your pleading, so go ahead.
Yeah, and so for reference purposes for other folks attending, it starts at page 8. The first has to do with getting some clarity on the scope of the confidentiality claims, just so it's clear, what parties can access with or without signing a confidentiality agreement pursuant to whatever protective order you issue.
Mr. Throne, I'm going to stop you for a minute. I want to go through this issue by issue. So right now, I'd just like to continue talking about the turnaround time.
Yes. Okay. Then let me just go directly to item number Roman numeral 4 there on page 9. There's a commitment in a stipulation that was filed on May 7th for some additional modeling in this case by P&M. And so given the somewhat expedited procedural schedule that you've established to meet, what P&M is asking for in terms of a final order, it would be helpful if we could understand how much time it's going to take for P&M to perform the modeling committed to there, so that, because that which would be available to all the parties.
Okay, and explain to me why that is relevant to this case, because you're referring, I think, to the P&M merger case there.
Yes, there is the stipulation filed on May 7th contains a number of regulatory commitments by P&M and by the other joint applicants in that case. And paragraph 53 in particular addresses modeling, not only in the IRP docket, but also in this case, to which P&M committed. And so there's a timing issue here, obviously, and it's just going to help to know, and that provision provides, and I quoted in the pleading, that provision provides that the modeling will be done and available to anybody who requests it in discovery. Onward will be requesting it, and we assume other parties who ask for discovery will also have access to the same modeling.
Okay, and could you point me to where in your statement you quote that language?
Yes. Page 7. It begins. And finishes in page 8. That paragraph and that's indented. That's word for word the P&M commitment in the stipulation. And I would also point out that commitment is not contingent upon ultimate commission approval of the stipulation. We have a situation here, as you probably are aware, where there's a number of sort of overlapping P&M cases. So that's why it's an issue, I think, that's properly addressed at this time in this status conference.
Okay, so that provision does not state how long, whether P&M is committing to producing the results of a modeling run within a certain amount of time, and you're asking for such a commitment?
Well, I just want to, trying to get some, an understanding from Mr. Phillips, since he's the one that, as I understand, is in charge of the modeling, since we understand that, they want a longer period than the 11-day discovery period that you established previously, try to get some idea about when, from the date on which we or any other party first request that modeling, how long it will take, just so we get an idea of that, because if it's a really long period of time, it may be a problem procedurally for us to analyze it and do whatever further discovery we may wish to do before testimony is due in this case.
This is Rick Aldridge, Madam Hearing.
Go ahead, Mr.
I appear for P&M in both cases. I don't think this issue is really different than what I understand you to be asking about, which is the turnaround time for requests for modeling in this case. Perhaps it's tangentially related, and what Mr. Throne is really getting at is the question of, well, are we going to have to wait to ask this particular modeling run until we know what happens in the merger case? So we're happy to address that, but I think you wanted to focus on the turnaround time for modeling, and so that's I think what parties should address right now.
Madam
Mr.
Hearing,
Throne, go ahead.
Yeah, I don't think Mr. Valvidris understands the point that I made. We're just trying to get an understanding on modeling. This is a commitment that, not that we would do this modeling, but that P&M is going to do the modeling, and it's going to be there for all parties. So we're just trying to get a sense of how much time that's going to take from the time we or any other party, when files a request for that, because that's literally what that provision that I laid out in the pleading states.
Ms. Padilla?
Madam Hearing Examiner, yeah, Leslie Padilla for PNM. If that's the narrow question here, I think the language that Mr. Throne is looking at answers it. It says through the discovery process in case number 21-00083. That's in about the midway of the provision of the stipulation that Mr. Throne cites. So I don't think there's any basis for any different treatment in terms of timing of any request that he might make. And Mr. Alvidrez may want to be able to discuss this a little more detail, but I also think Mr. Throne's statement that we would agree to make it available to all parties, I don't think that is accurate.
Well,
and why are you saying that?
Just by the language that I'm reading in the that Mr. Throne quoted from the stipulation.
Well,
let me follow up with Ms. Padilla real quick. So setting aside this paragraph from the stipulation, my understanding from the procedure adopted in case number 19-00195 is that you will provide runs for any party upon request. Is that correct?
That is correct.
Okay. Mr. Throne?
yeah, again, if you look at the quoted language in that section, beginning with the word through about halfway down, says through the discovery process in case 2183 UT, P&M agrees to produce upon request by any party modeling runs that include, et cetera. So all we're saying is, as you know, if we request it or anybody else does, anybody else that's requested discovery in the case has access to the same discovery. So that's all we're saying. So I don't know what the point of disagreement would be here by P&M.
So okay, no, I understand that, Mr. Thone. Thank you.
Okay. So I do want to avoid, I don't think it would be, it's fair to P&M, as Mr. Phillips described, that it receives requests for modeling runs pretty late in the process before the hearing. So my first two questions are, was there a deadline in case number 19-00195? Well, just one question. Was there a deadline for requesting modeling runs?
Leslie Padilla for P&M. Mr. Phillips, do you know the answer to that? Or Mr. Alvidrez?
Nick Phillips for P&M. My recollection was there was no formal deadline set. We would like to request that no modeling runs during rebuttal, and probably a month prior to the filing of testimony in direct would be sufficient. But even a month before, if we get 15 requests, a month before, it could be problematic to process all of those. So we would like to have a reasonable number then, that we are expected to process per party. I think that San Juan was a much more widespread case with a larger number of issues than this case is, as well as the modeling was more complicated in that case compared to this case. Another thing that really would help us, and we tried to do this in the San Juan case, and I believe it was in our proposal in that case, is that when parties are submitting the requests, they should modify the Excel inputs and just give us the Excel inputs so that we can run them that way. So there's no ambiguity with respect to what data they want us to use or what assumptions they want us to use. That ensures that we can process them more quickly.
Okay, I want to go back first to, with respect to, you said PNM, I think was requesting 2 deadlines or 1 deadline for parties to request modeling runs. Could you clarify that for me, please?
Yes, Madam Hearing Examiner. We would request that in order to try to process modeling requests prior to the filing of direct testimony, that we receive them at least 1 month prior. But with that, we would still want to make note that if we get a flood of requests on that 1 month date, it may not be possible to process them all in time, but at least 1 month prior would be preferable. We do not think that processing model requests during the rebuttal period is appropriate. We'll need to focus our resources on our rebuttal case at that point since it's simultaneous.
Okay, so I just want to get one clarification. You're requesting that you receive all modeling requests 1 month before the filing of staff intervenor testimony?
Yes, that's correct.
And you're saying that if you receive a flood of requests during that 1 month period, you might not be able to respond with the results of those runs by the deadline for filing staff intervenor testimony. Is that correct?
That's correct.
Okay. Any responses to that?
Madam Hearing Examiner?
Yes, Mr. Throne?
Yeah, just a point of observation. My recollection in the 19195 UT case was that, and this I'm not disputing what Mr. Phillips said, but my recollection was actually at the request of some parties, there was modeling done during the hearings and even up to the end of the hearing that was performed by PNM at the request of certain parties, some informal, some not formal. So I'm not saying that whatever your procedures, or I'm not disputing that parties, PNM is correct that, parties should get modeling requests in sooner than later. That makes perfect sense. But I just don't think that, well, I think you should be aware of that fact that was happening. In fact, a lot of the modeling requests that were done during and at the end of the hearing in that case were actually relied on not only by the parties in their briefs, but I think by the commission in its final order.
Does anybody else want to respond to that?
Madam Hearing Examiner, if I could, this is Joan
Introduce
Drake.
yourself, please.
Sure, this is Joan Drake for Interwest. As I recall from the 19195 case, some of those crunch issues that I think we're talking about here with respect to deadlines and late requests and multiple requests for different runs in that case were caused by parties not having enough information regarding the assumptions and inputs to PNM's runs that they did. We had to go through multiple discovery rounds in order to glean that information, and that consumed time. It consumes a lot of time, and that's partly, perhaps not entirely, but partly why I think we run into these kinds of crunch situations coming up against direct testimony deadlines, hearing deadlines, and so on. That's partly the reason why Interwest, in our statement of issues to you, asked for transparency and information upfront for everyone regarding the assumptions and the data inputs into PNM's modeling runs, so that we can kind of cut through the inefficient time consumption of trying to figure out what those assumptions are, so that all of us, not just Interwest, but all of us can figure out, are there other assumptions and modeling runs and inputs that we would like to see in modeling runs? So I just raised that because although it doesn't appear perhaps on its face to be an issue regarding access and timing, it actually is. I think it's important with respect to the timing here and the crunch that comes with deadlines. So we would request that you require PNM upfront to identify its modeling run assumptions and data input, so that we all have that information upfront. Thank you.
Madam Hearing Examiner, this is Mary Ellen Nassi, New Energy Economy. I would just support everything that Ms. Drake said. That is really what happened. That's the crux of the time inefficiency, is that we're trying to find out what are the inputs, if they're legitimate. Then we have to go back and try to, Mr. Phillips alluded to this actually when he first spoke and said, oh, well, I want you to tell me what all the things that you want us to assume. Well, the issue is that you have PNM's model, and it comes out, and you have to dig in and find out what are those first assumptions that were made. And then you don't want to have something totally different, because then it can't be compared. And then they argue that it can't be compared. So if we could know ahead of time what those initial inputs are and assumptions that PNM made, then we can decide with our experts which of those assumptions are in our minds legitimate or not, and we'll keep them, and that way that will be sort of like a control, and which are not. And then we have to explain them to your honor at some later point. So that's really one of the big issues. And I just want to also confirm what Mr. Throne said. Literally, it was days to the end of the hearing, like 3 days. And, the hearing examiners ordered PNM to run a model because of, and change an LOLE number or something like that, just to figure out what was happening at the very end. And that is what happened. And so I would object to any refusal to run no rebuttal testing, no runs in rebuttal. Thank you.
So Ms. Nanazi or Ms. Drake, can you just give me 1 or 2 examples of what you mean by an assumption and an input?
I think we, in our statement of issues, we gave you some thoughts, but these include something like cost assumption, transmission cost assumptions, how the scenarios were formulated in order to consider a range of possible different futures, the benefits of increased transmission expansion. But I think there are probably a lot of other assumptions that go into defining a modeling run. And I'm not an expert on that, so I can't detail all of those for you. But I think that Ms. Nanasi mentioned at least one of them. What's the LOLE assumption? Are there any constraints regarding particular types of resources that can be allowed in a resulting scenario or portfolio? Maybe others can think about what those other assumptions are. And I would invite anyone else, especially those who were involved in the 195 case, because my memory is getting dimmer on that, but I know there were a number of specific assumption issues that were problematic in that case.
And excuse me for my ignorance, what is LOLE?
Nick, could you help? It's loss or
Loss
something.
of load expectation.
Thank you. Loss of load expectation. It's my understanding is that is a reliability criteria, which is of course very important in this kind of consideration for replacement resources. Nick, am I right about that?
Mostly, I would note that LOLE is an output of the model. You define a threshold that you target, but the LOLE is an output, not an input.
Okay.
Ms. Padilla or Mr. Alvidrez, do you want to respond to the concerns expressed that a lot of the delay was caused by the parties not having sufficient information about P&M's assumptions and inputs?
This is Rick Alvidrez. Yes, I would like to respond to that. And I think a lot of the party's perception is P&M, the modeling that P&M is now utilizing, it's much more sophisticated. And there's simply not a lot of firm understanding by the parties and their counsel, myself included, in terms of some of the nuances. So it's much more complex. If you look at the testimony that's been filed in this case, it's rather comprehensive. And we do talk about LOLE, we do talk about the assumptions that were used in the modeling. So this case is very transparent, and the information is there if parties will read the testimony carefully, and including the exhibits. And so we have laid out essentially all of the inputs, the assumptions, and what have you. So that is not going to be, should not be an issue in this case. Part of it also has to do with timing. A lot of times parties don't get their discovery to P&M until right before they have to start preparing their case. And it's not a situation where P&M is hiding anything. It's just the parties didn't ask for the information at the early part of the case, and so they complain about when they get it later in the case. But I think if you even just a cursory look at the testimony of the three modeling witnesses that have been presented in this case, you'll see that the assumptions are quite well spelled out, and the inputs are available to anybody in terms of what actually went into the models that were used. So I don't think that that's a legitimate criticism, particularly in this case. With regard to the requested deadlines, I think Mr. Phillips has articulated a very rational reason, and even Mr. Throne acknowledges that it's not fair to wait and then have P&M crammed at the last minute in terms of trying to accomplish a number of modeling runs. The issue of modeling during the hearing is something we would like to avoid. That is not an efficient way of presenting the case. Perhaps it was necessary in the 19-195 case, but what we're trying to do is avoid that logjam in this case, and we think it can be done if the parties proceed in an orderly fashion and submit their modeling requests in advance. The other thing that Mr. Phillips has stressed is the part where, in this case, P&M is offering parties access to the software. They can do their own modeling and avoid any of these questions. And that's really what we encourage parties to do. All of this can be avoided. Much of it can be avoided if the parties will simply conduct their own modeling. And we think that creates less of an issue in terms of misunderstandings. And unfortunately, P&M would get modeling requests. There were, the modeling requests were missing, inputs and data. We'd have to seek, clarification of what what other assumptions, you're missing some assumptions, what other assumptions do you want to include? And so that process is not very efficient, but if parties use the tools that are available to them free of charge, I think much of this discussion is something that we can avoid. Thank you very much.
Madam Hearing Examiner? You're muted, Madam Hearing Examiner.
Thank you. Our landline was ringing. Mr. Alvidrez, who are the 3 P&M modeling witnesses?
Rick, you're muted.
We have Mr. Phillips, of course, Mr. Schlag, and Mr. Wintermantel. And the 2 primary modeling witnesses are really Mr. Phillips and Mr. Wintermantel. Those are the 2. Mr. Schlag provides some additional backup with regard to primarily what we call reliability issues.
Mr. Phillips, did you want to add something?
Yes, just to hopefully help clarify, all of PNM's inputs, assumptions, and outputs were provided in discovery, and once the confidentiality agreements, they will be provided here. And if parties take advantage of accessing the modeling software themselves, it's much easier to discern what's going on when you're using the computer interface rather than just looking through a number of Excel spreadsheets. So I just wanted to make note that, if parties are going to access the models and do their own runs, it's a lot easier to understand what's going on when you're using the software as opposed to just looking at numbers in a spreadsheet.
Yeah. Mr. Gould, do you wanted to respond?
Yes, very briefly. First of all, thank you, Leslie and Nick, for agreeing to what we proposed, and we'll read that into the record just later so that everybody understands what we propose and what you're accepting. But I would just say that this is a very, very nuanced subject. The models that were run during the middle of the hearing in 195 were slight changes to existing models that have been run. So we really need to be flexible. That's our only message here. And, if we set some limits, if we don't have any problem with that, but we'd just like the hearing officer to be very conscious that there may need to be exceptions. Because in the hearing, it was essentially a couple of models that were proposed, a couple of results that were proposed by Western Resource Advocates, and parties had questions. Well, what if you change this one feature of that portfolio? What will happen to the LOLE reliability standard? And so that was able to be done in a couple of days, as I understand. So that's the only, starting from scratch and doing your own thing, or giving PNM a modeling run that has 12 different assumptions is a much harder thing to do than just tweaking one little feature in the whole program.
Mr. Throne?
Yes, Madam Hearing Examiner. Let me respond to a couple of comments Mr. Alvidrez made. I did check with my client's technical people about the access that's being offered through the virtual machine, so-called cost-free. What I'm told is that unless you have somebody within your client that knows how to run the 2 models we're talking about, the Encompass and Serve-M, which is the reliability model, it really isn't something you can work with. You'd have to go out and get someone who has expertise in that. And I think staff is previously, I believe it was in the IRP case, pointed out they don't have the resources to do that either. In terms of the inputs, and you asked for some examples, and I remember that two of the outstanding examples that were addressed in the 195 UT case, there was a certain assumption about the forced outage rate for the Four Corners plant was one of them. Another one was whether or not the assumptions on PNM's assumptions on limitations on their import ability. Those are assumptions that other parties looked at and challenged, and as a result of which, Actually, the commission adopted, I believe, a portfolio was proposed by CCAE in that case that based on the commission's finding that those assumptions weren't fully justified. In our situation, one of the things that wasn't transparent in the filing, and I have read very closely Mr. Schlag's testimony, Mr. Nagel's testimony, Mr. Phillips' testimony on what their assumptions are. That paragraph 53 that we mentioned earlier, that is intended to identify a resource option that wasn't modeled, that they've committed to modeling. And the other point I'd like to make is, in terms of transparency of the assumptions, there's some confusion here, and that's one of the items that we had asked in our statement to try to get clarity on. In the IRP case, P&M filed a statement indicating that there were only, I think it was in their motion for protective order in that case, there were only two categories of data that they felt were confidential that should only be disclosed pursuant to protective order. And that had to do with competitive coal pricing. And the other had to do with information they got, and this was somewhat confusing, in a what they call a request for information, RFI. They refer to a 2020 RFI request. The IRP refers to a 2019 RFI request. So I wasn't sure if there was some different request they were referring to. But I think the difference is now in this case, and P&M's statement the other day said their modeling would be somewhat different in this case than the IRP case, but didn't explain all the reasons why they would be different. But one of the things that we believe would also have to be protected pursuant to established, P&M and commission procedures would be any competitive bidding that was submitted in response to P&M's June 25th, 2020 RFP. And the testimony, the direct testimony filed by P&M in this case, by Mr. Nagel and Mr. Phillips, make it very clear that the modeling in this case is based on the modeling that P&M did in its IRP, including information and proposals that they got in response to the 2020 RFP. So to put a fine point on it, that's why we raised in our statement, trying to get clarity in terms of also what Ms. Drake asked for, getting access to the inputs. It's two issues. One, how do parties get that access as soon as possible so they can do their analysis. And the second is trying to get some clarity about whether or not access. P&M has previously said that anybody who wants access to that has to sign a confidentiality agreement. And there's not a problem with me or Mr. Yar signing one. We're not involved in the competitive process. But in terms of the assumptions in the modeling, we think that ought to be available to all parties except for competitively sensitive information without signing that. And that's of importance to us because otherwise we can't share any, Mr. Yar and I cannot share any information regarding the inputs in the modeling with our client because our client was a bidder and we're certainly respectful and have no problem with making sure that, the competitively sensitive information is protected, and we're not certainly seeking any competitive advantage in that regard.
Okay, I want to go back again to coming up with some procedure that will avoid the delay that Ms. Drake and Ms. Nanazi said was a source of the late request for modeling runs. So what I'm going to propose, and you can respond to me, is that staff and the interveners by sometime next week file a request after you've reviewed the P&M testimony of the modeling witnesses, to file a request for specific assumptions and inputs that you want P&M to produce. And then I would set a pretty quick deadline for P&M to produce that information. So, and then, okay, let me just stop there. Does anybody want to respond to that? Does anybody want to object to that?
Madam Hearing Examiner, Rick Alvidrez. If I could get some clarification, are you indicating that staff and interveners should coordinate and submit a single unified request for information, or is this going to be where people just, develop their own requests and P&M is inundated with, 13 different requests, requesting some overlap and some perhaps not? But can you clarify what process you're imagining?
Well, I hadn't really thought about it that specifically. I don't know if any staff and interveners want to chime in on that, on whether you think you could come up with a combined filing, Ms. Zuer?
There really could be dozens or hundreds of inputs to these models. And I was thinking it might be easier for P&M just to catalog them and explain them, because one of the issues is understanding it. You have Excel spreadsheets and everything is in codes, little acronyms and codes. And a lot of discovery time is spent just trying to figure out what these things are, so you even know how to formulate a discovery response. So my suggestion would be for P&M just to provide like a Rosetta Stone. What is all this stuff? And before we can even ask what assumptions to seek from P&M. Thank you.
Madam Hearing Examiner, this is Joan Drake. I completely agree with that. A lot of times we don't even know what questions to ask because we don't understand what they've already provided, because it is obscure. And some parties, including staff, may not have the technical expertise to understand that at the drop of a hat, or at looking at an Excel spreadsheet. So I think it would be efficient and more expeditious for P&M to provide us with their explanation. And then if parties have questions or concerns with that, we can follow up. But at least we'll have hopefully a plain English explanation of what their assumptions and inputs are that we can then react to. Thank you.
Mr. Albright?
Madam Hearing Examiner, Mr. Albright for the county. I would concur with that. I mean, it's been years since I've done any modeling myself, but my experience is that given the number of inputs and the variables, you have a lot of sensitivity analysis. In that one or two of those many variables that you provide as input could be key drivers with regard to producing an output. I know in the 195 case, that's where the LOLE came into play, where there were a few specific elements that were driving the numbers, and the LOLE results were questioned in that case as to what the desired LOLE might be versus what it actually was. But given the number of inputs that we have in the case, an explanation would be great. And the key, there's probably just a handful of those, say 100 different inputs that are main drivers in producing the outcome. So explanations are absolutely critical. And I haven't looked closely at all of the testimony to determine or try to figure out which ones are the key drivers in the modeling that would, but a sensitivity analysis on some of that might be useful.
Mr. Throne?
Yeah, I agree with the statements made prior by counsel for the interveners. I would just add two things. One is You know, with all these assumptions, obviously different parties may have different views about whether or not a particular assumption is reasonable and justified. And so I think providing the parties with all the inputs is the point, so the parties individually can make their judgment with their experts on whether or not they feel a particular assumption has been justified and is reasonable. And that, as Mr. Phillips pointed out, changing those assumptions can drive outcomes, including whether or not P&M is able to hit whatever reliability criteria, that is the LOLE criteria, that they believe is appropriate in the case. And so I just think that rather than, you know, if all of that is provided in a transparent way as soon as possible, I think that's the most efficient way to allow parties to you know, address whether they want their own modeling, to do their own modeling, or ask P&M. And the other thing is, and we were a party that, you know, we were offered a limited modeling by P&M opportunity in the 195 UT case, which we took. And again, we understand that when, you know, we asked just very few assumptions be changed, and then we wanted to see the results. Of course, P&M is always free to argue whether or not they believe the assumptions that they want you to model are reasonable or not, and then the commission gets to look at that. But there is a huge difference between P&M doing the modeling and independent modeling. And that's really important, I think, for the commission to understand. And that is because if P&M does the modeling with only well-defined changes in the inputs that are transparent to everybody in the commission, then it makes it a lot easier to address whether or not the results of that modeling is something that should be relied on by the commission. If an independent party does its own modeling and it's not consistent with other inputs and assumptions that P&M has used, then it's pretty easy for P&M basically just to say, well, you know, that's not credible. We didn't do it, and it's not consistent with our modeling. And then the commission's in between a rock and a hard place, because you really don't have the ability to sort that out. So that's one of the reasons why we do support the idea of a limited amount of modeling by P&M being available to parties, particularly that have limited resources. Thank you.
Madam Hearing.
Okay. Briefly.
Very briefly, Marielle Nanasi for New Energy Economy. A perfect example is this case. So in 195, all the assumptions included purchase of the 114 megawatts of Palo Verde, all of them. And we, with Mr. Throne, I asked Mr. Throne to ask one of the runs be the same exact thing that they were doing, except take out the 114 megawatts of nuclear. Well, it turned out that that is exactly what they did. So that's why it's very important. I just wanted to give you a real life example of, you know, what kind of inputs, if changed just slightly, make a whole lot of difference in the output. And that's an example, that's a real life example that happened in this case in 195, and now we're here. So I just wanted to share that with you. And so that's the kind of things like what are the resources that you're assuming? What are the costs that you're assuming for those resources? What are the escalation values that you're assuming for those resources? They know all of this, and it would be very helpful if they just laid it out very transparently. Thank you so much.
Okay, but just a minute, before I hear from Mr. Alvidrez, yes, Ms. Beatles, go ahead.
Yes, Sydney Beatles for purposes of the court reporter. I did not actively participate in the San Juan replacement case 19-00195, but I understand that there were a couple of one or two technical workshops or conferences early on. And I would like to raise that as an option, not instead of the catalog approach that Ms. Jour described, but maybe in addition to that. I understand that P&M's right about seeing it within the models easier, but we do believe that PNM should be trying to help parties that aren't modelers. So I would just like to propose the idea of a technical workshop. Maybe another party, time permitting, could explain whether that worked well.
Okay, before we go to that, do any other interveners or staff wish to comment on the proposal by interveners that PNM provide in a filing assumptions and inputs up front fairly quickly?
Yeah,
Mr. Borman?
this is Brad Borman with staff. I think that sounds like a really reasonable and helpful proposal, so we would support that.
Okay, Mr. Alvidrez, do you want to respond?
I do, and I'll also ask Mr. Phillips to weigh in, but I think this illustrates something that I talked about earlier. And to make clear, those who access the virtual machine will have access to all of the inputs. That it comes loaded with the inputs. So everything that the model that PNM ran, models that PNM utilized, and inputs that PNM utilized will be on those machines. I think what we're seeing here is that this is a highly complex technical area, and a lot of the council, myself included, don't really understand it, and we would greatly benefit having technical experts to assist us in terms of the information. I don't believe that there is a practical way for, and PNM's not opposed to having technical conferences. In fact, one of the things we talked about in terms of making access available to the virtual machines is there would be some technical conferences up front about how to utilize it. But I don't think it's practical that PNM is going to be able to educate all the parties sufficiently where they're in any appreciably better shape than they are now without having their own technical experts to help. But what I would like to do is ask Mr. Phillips to expand upon this a bit. He is the expert in the room, if you will.
Sure, go ahead, Mr. Phillips.
Sure. Thank you very much. In terms of the inputs and the process and all that, one thing I would point out is that we have a very robust public advisory group through the integrated resource plan. We go through all the development of all the inputs. The IRP document itself is over 400 pages of descriptions of how we went about things, the inputs, sensitivities, how we develop the scenarios. All of that information is out there, and that combined with signing a confidentiality agreement to get the data dumps really gives parties everything that they need. If they need technical experts, that's up to them, right? So I guess I just have I don't know what they mean by a Rosetta Stone. It'll take months for us to put together a mapping of what every single input output type thing is. The easier way to do it is to have somebody who knows this already go into the models and provide consult to them on how to approach this. But we went through a year and a half of public advisory meetings. There's I think 14 presentations online from the IRP process about the development of the commodity prices, the fixed cost assumptions, all the things that we did, the load forecast, energy efficiency forecast, talking about how the scenarios were developed, all the things that the stakeholders now are bringing up. It's publicly available through the public advisory process of the IRP and the IRP document. And then moving into this case, the only thing that substantively changed was the RFP data being input into the databases and using that to determine specific resources as opposed to generic resources. So they are right. We did do some technical conferences, not about how to model. That's up to their own experts to know how to do. But we did technical conferences on here's how you use the virtual machines, here's how you access the software, and made sure that they could hit the ground running. But it would take years honestly, to try to get somebody to the position where they are an expert modeler if they are starting, from scratch day one.
But what about just providing a list of assumptions and inputs?
I mean, I understand what you're asking. The issue is that list is miles long. I mean, in order to put together a list of every single input and assumption, it's very, very burdensome because it's already there in the spreadsheet form. I know it's not intuitive to the human eye when you look at it, what it is. That's why you have to have experts to discern it. You want to get into the models and take a look at it. For example, the way that the model is set up, the Encompass model in particular, you would see a scenario, and in that scenario you can go in and see what each little input is for every resource, for which load forecast was used, for which commodity forecast was used, and then if you go to a different scenario you can see what changed between those two. And so that's the way to go in and define it. If you wanted us to take all of that information, take it into the spreadsheet, and then try to develop this mapping, we could spend the course of the entire case trying to do that before we get to something that the parties would say, well, this is what we were looking for.
Madam Hearing Examiner, if I could.
Yes.
That's precise. We sort of agree with Nick and then sort of don't agree. I mean, on one hand, Mr. Vidris is saying that the testimony makes it transparent. And then we hear from their expert that it ain't transparent at all. I'm just wondering, I think that Ms. Beatles had a good suggestion, and I'm wondering if it could be, those technical conferences could be simplified, not to have every single data point, but the major assumptions. Gas prices, explain that. Hydrogen prices, explain that. Import limits, explain that, why you chose that. High load, low load. Just kind of, at a high level, there's got to be only about 20 or 25 of those high level things, rather than, okay, on this day in July, when we modeled this in Encompass, it showed us this, but if we increase the temperature 5 points, that we don't need that, but we do need, how did you normalize the weather data? That kind of thing. I understand we've dealt with this and it is complicated. And that's why we decided to hire an expert. I mean, it really is this stuff, it's like, but the problem is that every single thing in those models ends up in a result that is the basis of this case. So it needs to be translated. It would be as if all of their testimony was in Farsi and they were saying, hey, figure it out. Go hire an expert who knows Farsi and he'll interpret the data. Most parties can't afford that. So we need the interpretation. And we're gonna do that on our own. And I will say one thing, PNM has been very cooperative in the informal process coming up to this meeting. We want to say thank you. The other thing is that we gained a lot of experience in 195. So from our perspective, it's a little simpler. ServM was the first time we'd seen that. And Nick in that case was very helpful of walking us through. We talked to Wintermantle. So if we can just keep the lines of communication open and we can simplify this a little bit for parties that don't have the resources to pay for an expert, hopefully we can get down the line and get to a good result in this case. So thank you.
Ms. Zor, can you propose any kind of middle ground? Because it sounds like from what Mr. Phillips said, it would take months to accomplish what your proposal is.
So first of all, some of the difficulty of understanding the Excel spreadsheets is simply trying to figure out all of PNM's abbreviations and acronyms, and nothing is spelled out. So that is all I'm suggesting. If you've got a couple of letters there, what does that stand for? So that's the very bare minimum. So when we have an Excel spreadsheet that has all the inputs, it should specify what each and every one, what those letters mean, say it. So that's not something so technical beyond anybody's understanding. And then what Peter said, there's going to be a number of major assumptions and so forth. And at least provide those at a minimum. And
Ms.
beyond
Glick,
that, I mean, that would be my minimum of what they could easily provide, in my opinion.
In a filing or through a technical conference?
They could provide it in a technical conference. They could email it out informally. They could do it as a response to a bench request, you know, whatever worked. Just get us the information so we can understand just what all your numerous abbreviations mean. Just like you do when you have a recommended decision. Your first pages say, here's all these abbreviations I'm using. We need to be able to speak the same language.
Ms. Glick, may I add one point to what I had a suggestion?
Yes.
This is Bruce Throne for Onward. So to be a specific input, I think it's pretty clearly described in the direct testimony filed by Mr. Phillips and the other P&M witnesses, and he can correct me if I'm wrong. But one of the assumptions in the modeling the P&M has made is that, that they'll continue to operate their existing gas plants until 2039, and that 2 of their gas plants will be converted thereafter to hydrogen or some other non-carbon emitting fuel after that, in order to satisfy their stated objective of becoming carbon-free by 2040. Now, that assumption is one of many, and if you change that assumption, then presumably we'll have some difference in the outcome, particularly on reliability. The cost assumed for hydrogen, the IRP discusses, that's based on literature, was not based on the 2020 RFP, which did not ask for parties to submit bids that regarding flexible gas resources that could be converted to hydrogen or some other non-carbon emitting fuel. So if P&M is able to provide and identify and explain all of the assumptions that parties ask for through discovery, then in early discovery, then I think each party will then be able to go ahead and be able to better prepare and develop their discovery regarding any modeling they want, because then they'll be able to isolate whatever assumptions they believe are important and may have a difference on the outcome. And it's really clear that, and P&M had made this clear in its direct, that now that it's not only trying to or aiming to comply with the higher RPS and zero carbon requirements established by the ETA, they're also modeling to try to hit their 2040 carbon-free deadline. So these are really important things for everybody to see, so they can really kind of get the best information they can in this relatively short time period to address really what's going to be the results of this. Because as Mr. Schlag makes clear in his testimony, whatever the commission approves in this case will have ramifications on the next resources that P&M requests in its next procurement case. Thank you.
So what do you think about, so first of all, let me say, with respect to what the abbreviations mean, I totally agree with that. I was assigned an SPS rate case a while back, and their attachments had all kinds of abbreviations, and I had no idea what they meant. So I ordered SPS in that case to make a filing identifying all the abbreviations. So I am going to do that at a minimum. Mr. Throne, what do you think about Mr. Gould's suggestion that there be a technical conference for P&M to explain, I think what he said might be 20 or 25 major assumptions or inputs?
Well,
and then that it seems like you're suggesting the remainder of inquiries be done through discovery.
Yes, certainly. I understand, Mr. Gould and his client, they have elected to do independent modeling, and we certainly respect that. We're not able to do that. And as I mentioned before, I checked with my client, and unless we were to go hire an outside expert, even though they have a lot of expertise on resources, they don't have the expertise on Encompass or Survey. So, I think both approaches would be very helpful, but I think in particular identifying, explaining the assumptions. And I guess the only other observation I would make is, P&M at this point, more than other parties, and Mr. Phillips will have a better idea of which changes of assumptions would have a substantive effect on the outcomes in terms of reliability, in terms of cost, that is net present value when they do their 20-year portfolios. I guess even though we probably wouldn't get much out of the technical conference, we certainly understand why that would be important to New Mexico area and anybody else who wanted to do some independent modeling. We think for us, and probably for a lot of parties in our situation where we're not going to do independent modeling and you're going to rely on discovery, the most effective thing would be to be able to get transparent disclosure of the assumptions, and then you work from there, because I'm no expert on modeling, but I can certainly read what P&M said, and I have studied in great detail the appendices to the IRP, and that's one of the reasons why I'd hoped this was going to be a joint status conference with the other case, but that's water over the dam, so to speak. But there is an appendix in there, and I think that was what Mr. Phillips was referring to earlier. There's an appendix that one appendices that deals with existing resources, one with new resources, that lists a number of the inputs that they used in the IRP. And the question then is, though, is the modeling going to be the same from the IRP in this case? And I raised this point in our statement. I don't believe it'll be exactly the same. There'll be a lot of similarities, but then P&M filed its statement and confirmed that the modeling is not the same. And so I think just referring people back to the IRP case, where, by the way, we haven't even gotten a deadline yet for filing on comments on whether or not that fully satisfies the commission's IRP rule. I don't think that's the answer in this case. But I certainly think there's benefits to what Mr. Gould is doing for his client.
Ms. Beatles?
Yes, thank you. 2 points. One is that when I proposed initially the technical conference, and it was picked up and expanded a bit by Mr. Gould, I was not thinking of a conference or workshop only for the experts, only for those who were going to do their own independent modeling, that it would also be a Q&A session, and perhaps that P&M could screen share or project if it was live, like the model, the inputs and assumptions in the context of the models, and to show us what he's talking about and enable us to ask questions and get answers. Also, I'm looking through the appendices in P&M's IRP right now, and I really don't see like a list of the input assumptions. There are a few major ones that are highlighted, but I really don't see exactly what Mr. Throne is referring to. I don't see a comprehensive, like, single list. It's just multiple appendices with various discussions. That's all. Thank you.
Ms. Strike?
Yes, thank you. Following up on what Bruce and Sydney just said, I actually think it would be most efficient and expedient for all of us if we could have a filing from P&M with these explanations clearly in plain English, and perhaps to make it doable for P&M to have them explain the acronyms, the abbreviations, and then the major, maybe 20 to 30 major assumptions. That seems a reasonable limit to put on this, and then follow up with a technical conference at which we could focus on that filing, so we all would have the same source of information that we could ask questions from. And that seems to me to be the most efficient way to go. I agree with Sydney that this kind of a technical conference would be most useful if it was geared towards not just a highly, experienced expert, but those of us, including yourself, the rest of us, commissioners, everyone who may not have a PhD in modeling, but have to deal with this anyway. And I think that would be worthwhile for all of us. But I think a technical conference, in my experience, would be most useful if we all had one document to work from, so that we weren't trying to pull from various sources that, may be confusing, inconsistent, and waste time, frankly. If we had one document we could refer to and ask questions from, I think that would be very useful. Thank you.
Ms. Gould?
Thank you, Madam Hearing Examiner. Just to clarify, I don't think that it was our position that the technical conference would just be for experts. We agree with the other interveners that we would like it to be for all people and to have a Q&A so that everyone can have a better understanding of what these models and the inputs are. And then I did want to follow up with Mr. Throne's comment. Along these lines, one of the things that I think we need up front is what is the difference between the modeling between the IRP case and this case, because a lot of parties, including ourselves, will be spending significant time and resources in the IRP case, trying to flesh out these models and what and these inputs and what we think they mean, and if we need more information or not. And if all that work in the IRP case is going to be for naught because PNM is going to say, well, this is different and you can't use that information and it's not the same, that's going to be really, really challenging. We also hoped that this would be a joint conference with Lennon, Hearing Examiner Lennon, because we do think that the cases are intertwined in the way that the inputs in the IRP case are going to inform the models that we run in this case. And the resources that are selected are the direct outputs of those inputs. And so it is hugely important to get transparency and connection between these cases so that we're not spending so much work in the IRP and then it's just starting from scratch again in this case. So I think that we really need clarity from PNM, perhaps in a bench request for them to specify everything that's different, that they did differently in this case from what they did in the IRP. And we also, this is, I know, another issue, we also need the protective orders to allow us to use our modeling.
I'm not getting there yet.
But, and then one other thing, Madam Hearing Examiner, I apologize. I have another meeting that I have to attend in 4 minutes. I didn't expect to butt up against this, so I asked to be excused at 10:30.
Yes, and we're taking a break at 10:30.
Okay, thank you.
Mr. Phillips, did I see your hand up?
You did, Madam Hearing Examiner. I guess the thing that I would like to point out is we already have made one of these filings that contains everything. It's our IRP document and all the appendices. There's an acronym list in there. There's, it spells out what all the scenarios are and what each of the different differences between those scenarios are. I think that stakeholders will all have different ideas of what the 25 most important inputs would be. If you were to survey them, you're not going to get a consensus of every single answer being the same. If we're going to go through this approach, I think the best thing to do is for stakeholders to thoroughly review the IRP, its appendices, all the presentation materials that we went through from the public advisory process, where we did have the owners of the models come in and talk about each of the inputs and outputs and all of those things, and make informed requests based on their understanding of that filing, because that really is the starting point of everything that went on into this case. I mean, there are changes. Yes, the main change is only putting in the RFP bids relative to the generic resources. So if they spend a lot of time reviewing the IRP, which was filed back in January, that will answer, I think, most, if not all, of the questions that are being raised here, because it's all defined in that document, the appendices, and the public advisory process.
Okay, I'm going to say gonna make a proposal, and then we're gonna take a break. Mr. Phillips, I understand what you're saying about reviewing the documents in the IRP case, but that's a different case. And I think that that information needs to be filed in this case. If it's the same information, I don't think it should be very time consuming for P&M to just include it in this case. So what I am going to propose to do, and we can talk about this a little bit when I get back, when we come back from the break, is to require P&M to make a filing identifying, explaining abbreviations, acronyms, to explain. I'm going to put a cap of 25 major assumptions, and I'm going to give staff and the interveners until the end of the day tomorrow to come up with a list of 25. Okay, so you need to agree on that. And then have a technical conference, and we can schedule that now when I come back, or you all can do that at a later time. So that's good. That's my proposal. I'll hear brief comments on that when we come back from the break. So let's come back at 10:40. David, are you ready to go back on the record?
Yes, Your Honor.
Okay. Just briefly, we have to move this along because Mr. Lee has a commitment. He has to leave, I think he said by around noon. So we've got to keep moving on this. Does anybody want to comment very briefly on my proposal, which again is that I would require P&M to make a filing describing abbreviations, acronyms, identifying differences between the modeling in the IRP case and this case, and to address 25 major assumptions that staff and the interveners will have to email to me by 5 o'clock tomorrow. And then there would be a subsequent status conference for any follow up. Okay, I need a little.
Mr. Throne wants to make a comment.
Go ahead.
Yes, just to get some clarification. One is, I think you said about parties filing something by close of business tomorrow, interveners and staff regarding the assumptions. I wasn't quite sure when you were anticipating requiring the filing by P&M in response. Obviously, they're going to need some time. I think it would be helpful for the assumptions that are identified that P&M add where in their filing they have identified the basis for the assumption. So we understand, where that is, where to look, and then can follow up if necessary through discovery.
Your Honor, this is Sydney Beatles. I guess I'm still a little unclear because you're asking staff and interveners to identify the major inputs or input assumptions or assumptions made about those inputs that we want P&M to provide or point out. I mean, I think that's part of the problem is some of us, maybe, other lawyers here at this conference have more understanding and expertise than I do, but some of us don't know what the major ones will be. I don't think that it just automatically is clear, like for example, in the San Juan replacement case, that the forced outage rate and the import constraint were going to make that big of a difference. I don't think you know that right at the start. So I think that, I think I would need more knowledge and understanding before I can identify or define what is major, and that's why I requested a technical workshop, but I do agree with Ms. Drake that it would be helpful to have some information in hand to make that process more focused.
Ms. Beatles, I understand your concern. This is a starting point. I am requiring staff and interveners to email the entire service list tomorrow with 27 items you want P&M to address in this filing. I understand you may not be able to identify them by then. This is a starting point. I am trying to get this rolling as soon as possible. Okay, so that's what I'm requiring.
Madam Hearing Examiner Peter Gould, this is an email, not a filing at the records department.
Correct.
Okay, thank you.
Okay, so this is the first case I've been assigned that involves this type of modeling. So I need a little clarification. When I require P&M to explain, describe abbreviations, what documents are you talking about? In what documents do they use abbreviations that they need to explain? Mr. Elliott?
Madam Hearing Examiner, I'm not familiar with ServM or the other modeling software, but separate and apart from the assumptions, perhaps it would be possible to ask P&M to provide us data directories a manual that identifies the field, the definition, and the formatting of the field. So is it a number? What does that number mean? And so forth. My experience with other systems has been that there's generally a manual of such that's provided to the end users. And that might be a good reference that we could maybe find some of these definitions in.
Okay, I'm going to come back to that, but I need an answer to my first question. When I order P&M to provide, identify abbreviations it has used, in what documents has P&M used abbreviations that they need to identify? Ms. Dorr?
The input and the output to the models. The models, sometimes they provide the output in Excel format. And again, it gives each item and the field, the value and just the list of items. There are abbreviations used.
But are you talking about abbreviations used in the Excel models, in testimony? What are you talking about?
So in responses to when they do a run in their models, and then through discovery, sometimes we'd ask for the output of those models. It would be provided in an Excel spreadsheet. So it was the modeling output. And to understand what those things mean, the first step is, what are all these names? What are these columns with the values? So just in the output from the Excel models.
So, Madam Hearing Examiner, Leslie Padilla
Yes.
with P&M. I'm just wondering if Mr. Phillips could help explain. Would that obligation be on us at the time we produced the run? We would, because I mean that it could produce a variety of results, right? And with possible different acronyms. Sounds like something we would be required to do at the point we're providing the data run to the requesting party. And I don't know if that really is what the work involved in that is.
So Ms. Zur, you're the one that proposed this. Are you requesting that P&M do it up front in a filing, or just in connection with its response to discovery requests and its production of the models?
I'm suggesting that when they do a run and there's an output, there's going to be a name of, in the first column of, here's what this first thing, this first, output is, and it's going to be the same every time. They're going to give an output every time that will have different values, but the run is going to have the same output. Is that not correct, Mr. Phillips? I mean, that's what I'm asking for. Simply, when you give us, here's the 100 different values that your modeling run generated, what does all this mean? Just simply identify the names of each item in there in a format that's not just an abbreviation.
So this is, an artifact of the software and the models themselves. If you view the data within the software, you do not see the acronyms. So if you take advantage of the software that's been offered, you will be able to see it very easily. But when you do a data dump on the output side, it can create hundreds of thousands or millions of rows, and creating a mapping, again, that's where it gets very, very burdensome. The high level acronyms are all documented in the IRP, and we can file that. But if you want a mapping of every single piece within the software that gets put into the data dumps, that becomes very, very cumbersome.
Madam Hearing Examiner, if I could.
Yes, Ms. Strike.
Sure, thank you. I think what you're looking for is for us to identify to you that what we are seeking in this filing from P&M are definitions and explanations of the acronyms and abbreviations that are in P&M's Excel spreadsheets that they point to and that they use as their evidentiary basis for the portfolios, whatever, runs that they did in this case that resulted in their proposal in this case. And you know, I confess I'm not intimately familiar with Mr. Phillips' testimony at this point. So, you know, he might have already included some of that in his testimony. What I think we're asking for here is a clear single filing from PNMs that we can all refer to, and it's clear, so we don't have to go hunting and searching and don't even agree on which place we got it from. But so I think if you're looking for what the source of the abbreviations and acronyms are, I think what they are is the Excel spreadsheets that are the result of the modeling runs that PNM did in order to support their proposal in this case. Nick, is that correct?
I mean, I'm still not clear what it is that you're saying. I mean, there's acronyms that represent different values within the model. There's acronyms that can represent different fields. You know, like for example, in the IRP, we use the acronym CTP for current trends in policy, which is kind of like the base case. That is clearly defined in the IRP document when you look in the appendices. And similarly, like, you know, HE would be high economic growth. But if you were to go and look at a different place in the output and a column header is VOM, well, that's an indication from the software itself of what one of the entries in the software is. It's not an acronym that PNM created. And so, you know, trying to do a mapping of all of this becomes very, very difficult due to the number of things that will be dumped out of the software. Whereas if you just go into the software itself, if you take advantage of the software, there's no more acronyms. Everything is just spelled out with labels and plain English.
Okay, two things, Mr. Phillips. One, we're not going to assume that all parties are doing independent modeling. So we have, making this decision, I have to target it to allow understanding by those parties that are going to have PNM do the modeling. Number two, you keep referring to the IRP case. That's a different case. The documents in that case are not going to be evidence in this case unless they are admitted as evidence in this case. So to the extent you're saying the information is in the IRP case, that has to be filed in this case.
We can file the IRP and all of the appendices and public advisory materials in this case. My suggestion would be is when we do so, if parties take a look at the acronym list there, and we can provide copies of the user's manuals for both the CERVM and the Encompass models, I think that gets them what they're looking for. If it doesn't, it would be better to come back after that and say, what is it that you need?
Ms. Glick, this is Bruce Throne. Just one point about your earlier indication that you were going to ask PNM to identify any changes in the modeling between relied on the RP. I think it would be really helpful to the parties and ultimately to the commission if the way that's done is if PNM identifies any changes in any of the inputs or assumptions or values between the modeling. And that way parties will have a much better idea how to go about dealing with the modeling in this case versus the modeling in that case.
Madam Hearing Examiner, this is Peter Gould for Anna Maria. Unfortunately, like my co-counsel, I have to leave too. I have a doctor's appointment that I scheduled a couple of months ago. And we'll just, of course, with any other case that we leave a hearing early, we'll accept whatever decisions you make on the protective order and other remaining matters. But I do apologize. I should have tried to reschedule that doctor's appointment, but this particular doctor takes a couple of months to get something set up. So I do apologize for no disrespect intended.
Thank you.
Thank you.
Ms. Drake, what do you think about Mr. Phillips' proposal to file the user manuals? And I don't know if we need the whole IRP filed in this case, but the parts of it that allegedly provide abbreviation explanations or identification of abbreviations.
I think it may be a start. And as you note, this is a starting point. I still think there's value to all of us to have the staff and interveners get together and identify amongst ourselves what we think the information that we need as a starting point is, and for us to suggest that to you so you've got that information as well. I think there's value in that. I think if there is information from the IRP case that's filed in this case, I think there does need to be explanations about what the differences are, because clearly there are differences, and I don't think we can take the information from the IRP case and directly apply it in this case. I think a necessary adjunct would be a clear explanation of what the differences are. And I should also note, I think what we're all looking for is clear English definitions of what are the inputs to each of these runs or scenarios that they run, and what are the outputs. I think we need both of those to look at the inputs and the outputs as well.
Ms. Beatles, briefly.
Yes, Your Honor, I have a question for Mr. Phillips. I'm wondering if he's referring to the acronym list, Appendix A to the IRP, because I think that's way more high level than what Ms. Jor is talking about with respect to a guide to understand the Excel spreadsheets, because the Appendix A to the IRP contains such definitions as FERC.
So that is part of it, but there's also Appendix J, which shows each scenario, future, and sensitivity that was run in the IRP, and the nomenclature for scenario analysis will be very similar. So if you were to see something that said CTP TN, it would be technology neutral current trends and policy, and we can easily add a column to that shows the abbreviations. But in terms of trying to judge what is in any given output report from either piece of software, that's more readily diagnosable from reading the manuals and understanding what each output provides. So if a column header said, again, as an example, FOM or VOM, for that particular software, it would be, fixed operations and maintenance is expressed in a, either $1 or $1 per kilowatt year type value. So, I mean, that's more of an understanding of what the specific output reports are. And that can be, again, readily diagnosed from reading the instruction literature.
Appendix J is an index and does not define or describe abbreviations or acronyms.
Right. What I'm saying is on Appendix J, you see a scenario, future, and sensitivity, and if you were to see a abbreviation or an acronym in an output report that said TN CTP, if we look at J3, technology neutral current trends and policy, I can add a column to this that would show, an example of how you would look at a scenario acronym and diagnose what the constituent of that scenario is. But in order then to go and understand, well, what is the underlying gas price, you would need to follow that through and say, okay, well, the low gas price is referenced in this other place. And again, it gets very, very complicated because there's hundreds of scenarios that are run.
Okay, Ms. Drake, I understand your suggestion that the interveners and staff get together and email me a list of what you think you need. I'm only going to consider that if you get back to me by noon on Wednesday. Otherwise, I'm going to issue an order tomorrow requiring a P&M filing.
Okay, okay. I'm not sure that I have a preference either way. If you want to issue an order to P&M tomorrow, I guess, could you explain again what that requirement would entail?
Okay, I'm sorry, it would be Monday because I need information from you all by the end of the day tomorrow.
Right.
So it would require P&M to identify, explain abbreviations used in Excel spreadsheets that show the results of its modeling runs. Number two, to identify any differences between assumptions and inputs in modeling in the IRP case and this case. And then it would require P&M to identify 25 assumptions used in its modeling to be provided by staff and the interveners by 5 o'clock tomorrow to me by email.
I think that's a good starting point, and subject to other parties' input. I like that idea as a starting point. We clearly will need some follow-up on some of these complex issues, but I think the sooner we get started on that, the better. I would ask what other folks think, but I'm certainly happy to meet with other parties tomorrow in order to get you some input by 5 p.m. tomorrow.
Okay, I'm not going to take any input from anybody else. That's what I'm going to do. Okay, so the next thing we need to address is a date for P&M, a deadline for P&M to respond to that order.
Okay. Madam Hearing Examiner, Leslie Padilla for P&M. I'd like to make sure I'm clear. Our response would respond to the staff and intervener identification of the 25, 27 major assumptions. Is that right?
Yes.
Okay. And then I also just want to be clear on the request for acronyms that may come in the output phase. Some of that, I think Mr. Phillips explained, we will have to provide by offering the technical manuals for SERVM and Compass.
That's the other thing. I'm sorry. I will ask you to file those. And it is fine in your response to that question if some of those acronyms are explained in the manuals for you to reference the page of the manual.
All right. Thank you. And in terms of a response deadline, I'd like to actually get some input from Mr. Phillips to have a good sense of when we can respond.
I guess one, it would be useful maybe if they could provide an example from the 195 case of what they're looking for, if at all possible. In terms of the response, I guess it really depends on what is all requested. I can get the user manuals, filed in a matter of a day or so. I mean, those we have on hand. Once we see the other questions, I guess that really comes down to what's being asked. I do have a number of staff members who have requested some PTO coming up, so it's not going to be lightning quick.
Well, it seems to me it wouldn't take very long for you to answer. I'm anticipating these 25 questions would be, what assumption did you use? I don't know exactly how the question would be phrased, but it would just be, what assumption did you use? I don't know why that would. Please, Ms. Padilla.
Sure, Leslie Padilla, if staff and intervener filing is by the end of the day tomorrow, is that correct?
Yes, and I would issue an order on Monday.
Then is it reasonable that PNM would have at least a full week to respond? I mean, as Mr. Phillips said, we can provide the material that's more readily available earlier, but I think I would ask for a full week.
That's fine. I think that's reasonable. So I would say the 24th, Monday, the 24th.
Madam Hearing Examiner, how are the parties going to, it's not a filing, I think you said it was an email. I gather you're not expecting emails from each of the parties. I'm not sure.
No, I expect you all to get together tomorrow, somehow exchange emails, whatever, and come up with 25 questions and email them to me. Okay, the next thing is, do you all want to schedule a follow-up status conference today, or do you want to discuss that at a later time among yourselves?
Madam Hearing Examiner, Leslie Padilla for PNM, we would prefer to determine a date for that schedule at a later date, just given staff schedule and, everybody's schedules.
Okay, and do you all think it would be helpful for me to listen in on this? Or appropriate?
Listen to the technical conference, you mean?
Yes.
I think so. I think that you might find it helpful, but I defer to others as well to hear what others have to say.
Mr. Albright?
Yes, Madam Hearing Examiner. Jeff Albright again with the county. I think that would be useful. I think at any hearing that we have in this case, it would, having that information ahead of the hearing and reference the discussion from technical experts would save a lot of time if you're a participant, but that's, I just think for background information and everything else, it would make the hearing much more efficient when we get to that point.
Okay, let me just ask then, does anybody object to me participating in that conference, either just listening or asking questions?
Madam Hearing Examiner, this is Rick Alvidrez. Would the technical conference be on the record?
Yeah, I think we should have a court reporter because, this may be the only documentation that we will have of some of the questions. So I think if it's not going to be in pre-filed testimony, I think we need to have a court reporter so that people can cite to the transcript of this technical conference.
I'm still a little unclear on what you mean by a technical conference.
Well, my understanding of what was being proposed, particularly by Ms. Beatles, is a follow-up to the filing you'll be making, a question and answer session where interveners and staff can ask other questions about assumptions and inputs.
And who, I mean, who would be present for the technical conference? Putting together a technical conference takes a lot of time and effort. So we would need to know what the expectations are. We would need to identify who needs to be there. We would need to check their availability. I mean, there's a lot that is involved in having a technical conference in the context of the IRP. These things took time to set up, and frankly, the IRP did provide a forum for the technical conferences, somewhat along the lines that you're talking about. In terms of if it's more directed about questions, follow-up questions to information that PNM provided, that's one thing. If this is going to be a presentation on here's how the various models work, and the inputs to them, that's a very different kind of thing. A lot of it is in the record already, but I don't think, unless I have a solid understanding of what the technical conference is going to be like, I don't know that we're in a position to say whether it's appropriate for you to be there or not.
Your
Well,
Honor,
yes, Ms. Beatles.
I just had a question, Mr. Alvidrez. Would your concern be the same if it were not on the record?
I would have, yes. In some ways, I'd rather have a record because that's an accurate, hopefully accurate, recitation of what transpired. But technical conferences typically are not on the record. Technical conferences typically do not involve the commission or hearing examiners in the context of a case like this. So it's a little unusual.
Well, my reason again that I think it would be good to have a court reporter is that if one of the interveners or if staff wants to cite in its testimony an assumption made by PNM or an input used by PNM, and that information is nowhere in PNM's direct testimony, I think there needs to be something that can be cited to support that assertion, which could be the transcript of this technical conference. I actually don't care that much about whether you want me involved or not, but I do think there should be a court reporter.
Well, so this again, becomes a little problematic. There are ways to get the information in the record without having a court reporter at a technical conference. If someone wanted to submit a discovery request and say, basically reiterating what they thought they understood at the technical conference, they could get that information. But what it sounds to me like is that we're going to have, in effect, another evidentiary hearing. I don't know if the presenter is going to be under oath. What evidentiary weight is the technical conference going to have? This is not a typical process from at least what I'm hearing and understanding.
Okay. That was just my initial thought. Does anybody want to respond?
Madam Hearing Examiner, this is Mary Ellen Manassi from New Energy Economy, and a lot is riding on the assumptions that basically are not transparent. Everybody admits and understands that this is super complex, and yet all of us who are, in all of these cases don't know what the basis is. And that seems to be problematic. And that's what this whole morning has been about, which is we're trying to decipher something so that we can actually critique it or accept it. But the fact that, P&M's position is we don't really want you to know about all of this because it's too complex is problematic, because so many decisions are being made that have consequences for decades and tens, if not hundreds of millions of dollars. So it's vital that this is the group that usually intervenes in these cases, understand what's behind or form the basis of these major decisions. So I think that the technical conference, we're all asking to understand. That's all we're asking to do, and have it be as transparent as possible and be recorded and welcome you there. I think that seems pretty reasonable.
Ms. Beatles?
Thank you. This has been done before. In the San Juan abandonment case, there were some resources proposed, and PNM invited the stakeholders down and explained the use of strategist in Aurora to us and entertained fielded questions. Mr. Albright's nodding, thank you. I don't believe it was on the record or that anyone asked whether the hearing examiner could or should be there.
What's your position on whether there should be a court reporter?
I actually think that may inhibit the exchange. I would prefer that there was not, and that for the information, people could follow up with discovery like Mr. Alvidrez suggested.
Okay. Anybody else want to express an opinion on whether there should be a court reporter? Mr. Elliott.
The Office of the Attorney General prefers erring on the side of transparency, and I think as you raised, this may be the only opportunity where some of these things might be addressed, and for the sake of making sure that everybody's fully informed, it may be beneficial to have a court reporter there for that purpose. However, I am sensitive to the idea that it might inhibit the free flowing of discussion, but assuming PNM is fully prepared to discuss these issues, I can't see why they would be controversial in any way.
Anyone else? Mr. Throne?
Yes, I think as long as it's limited to the identification of assumptions, inputs to the modeling, and where the basis is, and if it's tightly controlled, I think it is a good idea to have a record, and I think it's a really good idea for you to be there so that if there's any confusion about this, and I'm sure a lot of these things can be easily confused, at least you'll have the perspective of having attended and have whatever your understanding is of what happened.
Anyone else?
May I ask a question?
Yes, Mr. Phillips.
Would the technical conference be limited to just the responses or questions about the responses in the filing, or would it be more broad? This is just useful to know whether, like all witnesses should be present, or, just those who are, myself and say Mr. Wintermantle, who's a modeler. But, for example, if somebody says, well, I have a question about how a certain input was derived that was coming from a different group, we may not be able to answer that without having other persons present.
Okay, so this would not be limited to PNM's filing.
Thank you.
Okay, I'm not going to require a court reporter. I guess I agree with Mr. Alvidrez. That could get too complicated about do we need to have the witness sworn in, cross-examination? So I agree with Mr. Alvidrez on that.
Madam Hearing Examiner?
Yes.
Leslie Padilla with PNM, and I apologize for having to go back to the previous topic of the deadline for PNM's responses. Mr. Phillips is unavailable next week, which makes our preparation of responses in 1 week very difficult. But as I explained earlier, we will be able to provide some of the requested information very soon. As to the remainder of the information, I think it's really be our responses to the identified major assumptions. Is it possible to have a deadline of 2 weeks? That would be, I think,
The
2 weeks from Monday.
27th?
Yes.
That's fine.
Okay, thank you.
And the remainder would still be the 24th.
I think you had identified an earlier deadline for the information that we said we could provide more quickly. I think that was the, what did you say? Yeah, no, the 24th, the 24th.
Okay. Okay, so I may want to attend this technical conference, so let me just give you the dates that I'm going to be unavailable for the next, let's say, 2 months. So, and ask you not to schedule it on these dates. I will not be available May 31st through June 4th. I'm not available June 8th or June 9th. I'm not available June 16th or June 17th or 18th, or the week of June 21st, June 28th, July 15th, July 21st through 23rd. So actually, that's a lot of dates I'm not available. So if it doesn't work out, you can select a date I'm not available. So don't make that your priority. Okay, a few more things. You know, I'm assuming that staff and interveners, to the extent they are going to request that P&M do modeling for them, that they're going to want the results by the date that they file their direct testimony, which is August 20th. So I'm thinking it would be a good idea to set a deadline for staff and interveners to request modeling to be run by P&M to ensure that those results get back before they file their testimony. Does anybody object to that? Mr. Albright.
Madam Hearing Examiner, along those lines, I don't know what how much in advance other folks might need, but I would suggest we at least have 10 days before the testimony is filed. And it may take longer for some of the folks. I just don't know. We don't have anybody who's going to be doing independent modeling for us.
Well, the problem that I'm getting to is that P&M is committing to providing modeling results within 11 days, but if they get a ton of requests, 2 weeks before the deadline for staff intervener testimony, you may not be able to include those results in your testimony. So that's why I don't think 10 days is going to work. I think if we're going to have a deadline, it's got to be longer, and I'm not going to require P&M to commit to getting you the results before you file your testimony. So if you don't want a deadline, that's fine, but you're running the risk that you're not going to get the results by the deadline for filing your testimony.
Well, and that's where I was going, is that we're going to need those in sufficient time before. I mean, we can't get them like the day before we file our testimony, because we won't be able to incorporate it into any written testimony. So we're going to need some time prior to that date. And I was suggesting at a minimum, at least 10 days prior, and maybe longer. I don't know what's reasonable for the other folks either.
Oh, I understand. You're talking about a different deadline, which is a deadline for PNM to produce the modeling runs.
Correct. Yes, Madam Hearing Examiner.
So I think that then requires a deadline for requesting modeling runs.
Right.
And that's certainly reasonable too.
And Madam Hearing Examiner, Leslie Padilla from PNM, Mr. Phillips, at the outset of the meeting today, suggested 30 days in advance of the deadline for staff and intervener testimony for the requests, in order for us to be able to respond timely.
And are you willing to commit to a date? If, let's say I agree with you on that, are you willing to commit to get those results within a particular number of days before the deadline for staff intervener testimony?
For that answer, let me seek the input of Mr. Phillips. I kind of just know off the top of my head, it might depend on the volume that we get, but let me let him weigh in.
Leslie, you're correct. It really depends on the volume and the complexity of runs. My thought was, if we don't get flooded, a month would give us sufficient time to run a few runs for parties and get them, prior to their filing of their testimony. If they are saying they want them 10 days prior to the filing of the testimony, I would ask for 30 days prior to that, to have all requests in, for us to be able to try to process them in time. It's much easier to process a run, as an example, that just says change from gas forecast X to gas forecast Y. If a run says change 12 different inputs, to use an example that Mr. Gould said earlier, that can take sufficiently longer time, and it may not be possible even within the 30 days.
So,
Madam Hearing Examiner, Rick Alvey, if I may, the other issue really that I hope you will consider is a limit on the number of requests that an individual party can make. I mean, if someone hits the company with 25 requests, that would be unduly burdensome. So I think a reasonable number of requests is in order to avoid a log jam and depriving other parties as well of getting any data that they would need.
What I thought that was limited to 2 in case 19-195. Am I not correct about that?
I think you are in that.
What wasn't 2? Wasn't it 4?
It's 2.
Because I believe we had that was my recollection. I think it was depending upon when the timing was. I thought it was 4, but maybe you can check on that.
I believe it was 4 as well. Mariel Nanasi, New Energy Economy.
So I'm looking at page 8 of the order in that case. And at the very bottom, it says, first, SWG's request that the hearing examiners approve SWG's proposed procedure under option 1, that PNM be required to run up to 2 scenarios requested by a party, in addition to the 5 scenarios PNM proposes, appears to be premature. SWG has provided insufficient information for the hearing examiners to determine the reasonableness of SWG's proposal. So that seems to indicate to me, I don't know, did PNM, I have to go back and look at that more, and I'm going to adopt whatever was done in 19195. And it's not clear to me, just real quickly, if there was a limit. Okay, so I want to go back. Does anyone have any objection to setting a deadline of 30 days before the deadline for filing staff intervenor testimony for requests for modeling runs, and then requiring P&M to provide results of those runs by 10 days before the filing of staff intervenor testimony? Okay, so I'll include that. I'm really, at this point, unsure about whether to allow additional requests for modeling. So I think I'm not going to say anything about that at this point. And just see if that issue comes up, we can address it either through motions, or we can have another status conference like we're having today. I just think that I can't decide that today.
For clarification, is that with regard to during the rebuttal phase?
I guess so. I guess I would say whether staff and interveners can request additional modeling runs in addition to the ones they request before they file their direct testimony. I'm just not going to address that.
And Ms. Glick, just a point of procedure on what you want by tomorrow from all the interveners and staff.
I'm sorry, who is speaking?
Oh, I'm sorry. I apologize. Bruce Throne for Onward Energy. Since we're all kind of scattered, I'm wondering, and since most council, except for, I guess, the Goulds had to leave, are there, is there any way, I don't want to impose on staff or anything, but we can coordinate through staff to send obviously each party, there's a limit to how many requests. Could we coordinate this through staff? Is there a way to do this so we don't have to all, I'm just wondering, Mr. Borman, if staff could handle that, or maybe somebody else we could send our request to?
You're saying have staff handle the actual submission to the hearing examiner?
Yeah, in other words, we just send you, yeah, would that be?
I can take care of that if necessary.
That's appreciated. Thank you, sir.
Sure.
Okay, so I have a few more things, and then I'll ask if I missed anything. Okay, Ms. Padilla, maybe you can respond to this because Mr. Gould is no longer on the phone. He requested, and you said you didn't object to his proposal for P&M to set up 2 virtual machines for each requesting party, one for Encompass and one for SERVM, and provide a separate login for each. Is that something different that was done in 19195?
I don't know the answer to that part of your question, Madam Hearing Examiner. Excuse me, Mr. Lee, it's Leslie Padilla for PNM. But I believe NMArea's proposal was either the software licenses or the access to virtual machines. Mr. Phillips, I know you raised your hand too. Is that right? Am I understanding NM Area's proposal correctly?
Yes, and you know, the virtual machine idea, doing them that way it does create some significant burdens on PNM's end. If parties are going to take access to the software and want, you know, separate licenses for both to have people running them in parallel, we can just pay for the licenses for the vendors and they can install them on their own machines, and that doesn't create the administrative burden on PNM side.
So just to be clear, if I think NM Area's proposal was sort of in the alternative, if since PNM is willing to pay for software licenses, we would not make the option of virtual machines available. I don't think that there would be any need for it, as Mr.
Okay,
Phillips explained.
You're correct. It is an alternative proposal. Okay, so I'll include that. Okay, Ms. Padilla, in your email, you had requested some additional language to the confidentiality agreement. Is that still necessary, or are you still requesting that in light of my adoption of the procedure used in 19-195?
Right. Leslie Padilla on behalf of PNM. Again, I'll want Mr. Phillips to confirm, but I believe since virtual machines will not be an option, then that additional information about the logon credentials will not be needed in the protective order. But Mr. Phillips, could you confirm?
That's correct. If we are just going to pay for licenses that will be installed on parties' own machines, rather than setting up the virtual machines, we would not need the additional language in the confidentiality agreement.
Okay, thank you.
They would not be accessing our systems that way.
Okay, NM Area had requested a modification to paragraph N regarding use of modeling data in other commission proceedings. And I'm convinced by PNM's statement on that proposal by NM Area should be rejected. Because I think, Ms. Padilla, you said that something to the effect that you were not allowed to share data from the IRP case.
Exactly. There are differences, and this is one of the things I think we're being asked to actually explain then, either in our filing or at the technical conference. I can't remember which, but they're not transferable. So I think to do what NM Area suggests would cause a lot of confusion and inaccuracies in the future.
Okay, so I'm rejecting that. And then finally, the one last thing I have, Mr. Throne, could you go back and explain again? I think you were saying something about you want to be allowed to share RFP results with your client who was a bidder. What was that your issue?
Not exactly. Let me explain. So in the IRP case, there'll be inputs and stuff that don't identify any specific bidders or results of RFP, even though their RFP said it was updated to reflect information that was provided in response to their June 25th, 2020 RFP. So that's a separate issue. In this case, as Ms. Padilla and Mr. Phillips has pointed out, the modeling will be somewhat different. They are modeling specific responses, including, by the way, the modeling that's addressed in that or section 53 of the regulatory commitments and the stipulation in the merger case. So all the issue I was trying to get at is PNM's motion for a protective order in the IRP case said in order for people to access their inputs to their models, everybody would have to execute a confidentiality agreement. And then they said there were two categories of information in that case that were considered by PNM confidential: coal pricing regarding the coal plant, and the other was the results of their RFI that they addressed in the IRP. In the in this case, you're going to have the specific bids, and we want to make sure we can get. Well, council can sign the non-disclosure. That's not a problem. But there's always been some issue about if you're representing someone who is involved in the procurement process, which Mr. That I've never been involved in, and Mr. Yar has never been involved in, and we won't be involved in. Is the question is what can you share with your client? And so we don't want access. We want to make sure that the bidding information, identification of bidders, and specific bid proposals are protected by the protective order. But we also want to be able to share with our client the assumptions and inputs in the models that are not confidential. And so I know we're making a very fine distinction, but it is important to us because we certainly don't want to be in a position getting into a dispute with P&M over what we can provide access to. So what we were basically asking for is clarification in this docket from P&M that they would protective order will protect all confidential bidder information in response to their 2020 RFP, but also that we will be allowed there isn't confidentiality over the non-confidential inputs and assumptions in the modeling. And that's the distinction I'm making so that we can have total clarity on that. Hope that's clear.
Yep. Madam Hearing Examiner, Leslie Padilla on behalf of P&M. I think what Mr. Throne is proposing is just highly impractical, that we would go through and identify each assumption in the modeling and identify each assumption. I mean, we've already heard that itself is quite an exercise, but to identify each one as confidential or not, I don't think is reasonable or even possible within the timeframes required by this case. And then, so I think I could stop there, but also then the data outputs, because they do rely in part on confidential information, the outputs themselves, I believe, are confidential. Again, Mr. Phillips can explain in more detail if that's needed.
Well,
Rick Alvidrez, I believe a similar issue arose in the 19195 case, and the hearing examiner said that P&M was justified in claiming privilege or confidentiality. I'm sorry, for the very reasons as articulated by Ms. Padilla, which is it is not really practical to go through and identify each output and just where it falls on the confidentiality scale. I mean, if Mr. Throne wants to ask about specific things that he wants to share with his client, that's something we certainly would talk about. But I'm certain that Mr. Throne wouldn't want his client's information made known to other bidders and that sort of thing. So
exactly, but I think counsel for P&M is conflating what I'm saying. We're talking about just the inputs other than confidential bid pricing, and the only matters in the IRP case that P&M said were confidential and that were relating to the coal pricing. They made a filing with the coal pricing and the results of this RFI that they issued. They say it says 2020 or whether it's 2019. Now, we're not talking about outputs. I mean, outputs simply show you the results of the modeling. We're just talking about the inputs, and I just want to make sure. I mean, there's a limit. We're just making sure that they protect the confidentiality of if a party says, we want to see the bids that resulted in the basis for your modeling of this particular type of resource. We certainly think they should protect the identification of the bidder and the price offered. The output will simply show the results. So I think by talking about confidentiality of the outputs, I don't know what P&M's counsel is referring to, because the outputs of modeling, there's no reason why that should be confidential.
Mr. Phillips this is Rick Alvidrez. Mr. Phillips can address this very issue.
Right. So the databases themselves, when exported from the software, one big database, and separating things out is incredibly burdensome. On the output side, the data outputs are detailed enough such that if you know certain financial assumptions, such as a discount rate and other things, you can back into what the bid offered prices were for specific resources, which is why and same thing on the coal pricing. If you were to look at the hourly outputs of the coal unit or the monthly outputs of the coal unit, you could back into what the coal pricing was. So that's why the claim of confidentiality governs all of it.
Well,
And so, Mr. Throne, you're saying that the outputs and the inputs should not be confidential?
no, what I'm trying to get at is we want the confidentiality of bidding information protected. But I need, and Mr. Yar, who's not on the call, but he needs to be in a position so that when we see the modeling, we can at least discuss with the client the effect of the inputs on the modeling. If we can't do that, then it really makes it impossible for us to evaluate the model and its results. So we're trying to thread the needle, so to speak, here, and make sure that we can properly share the inputs that are not confidential. And I don't understand this issue of backing. Okay, I understand that if you're very sophisticated, you might be able to back out things like what Mr. Phillips is talking about. I don't think that's the parties in this case aren't interested in backing out those things. The parties in this case are trying to find out what's the results of the modeling, depending upon the assumptions upon which the modeling is based. So, we're, like I said, we just don't want to be, we want to be able, we've had this discussion in the P&M in the past. They haven't had a problem with sharing alleged confidentiality information with counsel. But then the question is, well, what can we share? And up till when we've done that, we've never shared any information that we had access to with the client. But now the question is, how can we at least discuss the assumptions with them without running afoul of the protective order?
Okay, so your request is that information regarding inputs and assumptions, that you be allowed to share it with your client, even though your client was a bidder.
Right, except for inputs or assumptions that are based on competitive bids. I mean, obviously, my client knows what its competitive bids are, but we're not trying to, we want to make sure there's no implication here that somehow by intervening in this case, they're trying to get some advantage in the competitive bidding process. I mean, the bidding process is over. I mean, that's not, but we've encountered this before, and I want to make sure that they're able to take a look and assess, oh, okay, we see why this result came out this way because there's this assumption. Give you an example. If somebody comes along, any of the other parties, and says, well, we think you should change that assumption, and that'll produce a different result. We want to be able to look at that, but again, without running afoul of any confidentiality concerns.
And what do you mean when you say except for assumptions based on competitive bids?
Well, if they have they have a model, and the model shows that they modeled a particular resource, and they based it, and their testimony already says this, by the way. To back up a step, their testimony says, look, there are two modeling paths, the same as we discussed in our IRP. One is called the technology neutral path, and the other is called no new combustion. And then they say in our replacement analysis, in this case, we relied on our no new combustion path, and Mr. Fenton explains why. I don't need to get into the why, but the point is, but then there's modeling for each. So the question then becomes, okay, when if they model the technology neutral approach, and you go into these lines, if they're saying, they've already said they base that on specific bids. Now, usually when they identify that, they don't give you the name of the bidder. They go bidder number 1, 2, 3, 4, et cetera. I mean, obviously people would be able to figure out, for instance, if it was our bid, okay, that's part of the, we understand that, but we're not trying, we're more than happy to agree, whether it's through a confidentiality agreement or through an order, that even though if we sign a non-disclosure agreement, we will not share any competitive bidding information with our client.
Mr. Alvidrez, can you respond?
I don't know that I entirely followed Mr. Throne's discussion, and I guess maybe perhaps competitive bidding information is in the eye of the beholder, and that's a problem. And Mr. Throne represents an unsuccessful bidder in this last go round, and we absolutely want to protect the integrity of the bidding process, into the future as well. And so P&M is very vigilant, and of course also has confidentiality agreements in place with the bidders that participated in the bidding process, such that other competitors cannot simply intervene and then have access to what is highly sensitive information. I think it's hard to talk about this in the abstract, as I indicated before. We're willing to, if there's specific information that Mr. Throne wants to be able to share with his client or something like that, we're happy to talk to him about it. But having this amorphous kind of, well, we don't think this is competitively sensitive or what have you, is not a very clear standard for us. And so we prefer to have what has been in place in the past continue to remain in place, and we will work with good faith. If there's information that Mr. Throne thinks he needs to share with his clients, then we can talk about what are appropriate conditions to do that, if necessary. And if necessary, we can come to you about it. But I hope we would be able to work it out.
Well, Ms. Glick, Bruce Throne again for Onward. I'm trying to get this clarified up front so we don't have a dispute. In the past, when we had one person this is in the 195 UT case, we had one person internally with whom we deal, and Mr. Yar will be dealing going forward. Sign a non-disclosure agreement. P&M objected, saying, "Oh no, you can't get access to any kind of competitive bidding information." And so, rather than have a fight over it, we just withdrew that agreement, and we didn't share it. Now, in this case, we have to have an ability to understand the modeling inputs. We're not going to do our own modeling, but we want to be able to understand it so that if parties change assumptions. And so all we're requesting is, rather than have us internally wrangle over this and spend a lot of time down the line, that you issue an order basically saying, and we're totally in agreement with this. And by the way, the comment about unsuccessful bidder, to the extent there was some implication here that we're intervening in this case to protest, that's not fair. We want to understand the modeling, and we want to basically be able to address the modeling in this case. So we would just want to make an order that makes clear that we can provide input information for the modeling to our client, provided it is not identified by P&M as information that was provided, competitively sensitive information that was provided in response to their RFP. That's all.
Mr. Alvidrez, do you want to say anything else?
Again, I don't think there's a bright line test, and so I think out of an abundance of caution, you know, it'd be much better if there's specific information that Onward wants to provide internally. They come to us and ask us about it. We've been able to work things out among parties in the past. We hope we could do that in this case, but you know, I wouldn't know how to interpret if you said non-confidential, non-competitive information. What does that mean? And there is a danger, as Mr. Phillips said, if you have all of the inputs other than, you know, some pricing or whatever, you can back into it. And you know, I'm not casting aspersions to Mr. Throne, but you know, this is, you know, competitively sensitive, beneficial information that a bidder, you know, would like to know if they're, you know, competing on a $100 million contract. So,
Okay, yeah, I'm not going to address this right now. If an issue comes up, try and resolve it amongst yourselves. If you can't resolve it, I believe there's a procedure in the protective order for addressing it. So that's all I have. We've only got about 10 minutes left. Does anybody have anything else? Okay, well, thank you all very much. I hope this was helpful. And I will plan on issuing an order on Monday.
Thank you,
Right.
Ms. Hearing Examiner. Mary Ellen Asty, New Energy Company. I just wanted to know, is the protective order that you sent out on May 11th the one that you're issuing in this case?
Yes.
Okay, thank you.
David, thank you very much.
Bet, Judge.
Thank you, Madam Hearing Examiner.
Thank you.
Everybody.
Thank you.